अस्सलाम वालेकुम जी। आई वेलकम यू टू माय चैनल। और थोड़ा सा ये सुप्रीम कोर्ट रूल्स के बारे में मैं जानना चाह रहा था कि सुप्रीम कोर्ट रूल्स जैसे जिस तरह हाई कोर्ट रूल्स एंड ऑर्डर होते हैं, जो हमें पता ही होता है, जो हाई कोर्ट में प्रैक्टिस करते हैं और इसको हम अमूमन पढ़ते हैं। सुप्रीम कोर्ट रूल्स एंड ऑर्डर अनलेस का कोई लाइसेंस ना हो नॉर्मली लोग नहीं पढ़ते, बट आई जस्ट वांट टू फाइंड आउट कि इसमें होता क्या है और Supreme Court rules, how are they different from the High Court rules, and in what capacity are they actually like, in what capacity do they run the entire system of our superior court या जो अदालतें उज़्मा होती है। कहते हैं कि अच्छा, ये मैंने इसकी वेबसाइट से लिया है जस्ट सो दैट यू नो। सुप्रीम कोर्ट की जो वेबसाइट है उसमें सुप्रीम कोर्ट रूल्स हैं, अमेंडेड 1980 के हैं और उसके बाद अमेंड हुए। ये मैंने यहाँ पे निकाल लिए हैं। मैं अब इसमें मैं देखना ही चाह रहा हूँ कि इसमें बेसिकली है क्या और इसमें कॉम्पोजिशन वगैरह के बारे में क्या लिखा हुआ है। अच्छा, कंपाइल्ड बाय सलीम अहमद, शायद कम असिस्टेंट लाइब्रेरियन है। टेबल ऑफ कंटेंट है, टाइटल इंटरप्रेट, ऑफिस ऑफ द कोर्ट, सिटिंग इन वोकेशन, ऑफिसर्स ऑफ द कोर्ट होता है, नोटिस ऑफ द मोशन, डॉक्यूमेंट्स, एफिडेविट्स, इंस्पेक्शन सर्च, जजमेंट, डिक्री एंड ऑर्डर, कॉन्स्टिट्यूशन ऑफ बेंचेस पे बहुत मामला आते हैं, कॉन्स्टिट्यूशन ऑफ बेंचेस पे। इंटरप्रिटेशन, दीज रूल्स शैल बी कॉल्ड द सुप्रीम कोर्ट 1980, ठीक है। इंटरप्रिटेशन तो आ गई। ऑफिस ऑफ द कोर्ट सिटिंग इन वोकेशन एक्सेप्ट ड्यूरिंग द वोकेशन and on court holiday and subject to any order of the chief justice, the justice of the court shall remain open daily from 8:30 on weekdays and from 8:30 am to 12 noon on Friday. ऑफिस ऑफ द कोर्ट है, रजिस्ट्रार शैल बी द एग्जीक्यूटिव हेड ऑफ द ऑफिस। जो रजिस्ट्रार होता है ये बेसिकली या तो एक डिस्ट्रिक्ट सेशन जज होता है या रिटायर्ड होता है या फिर एक फेडरल सेक्रेटरी लेवल का बंदा होता है। जो सुप्रीम कोर्ट का एग्जीक्यूटिव हेड होता है उसके एडमिनिस्ट्रेटिव मामला देखता है, उसकी ऑफिस है। ही शैल हैव द कस्टडी ऑफ द रिकॉर्ड्स ऑफ द कोर्ट एंड शैल एक्सरसाइज सच पावर असाइन्ड टू हिम बाय द रूल्स। द रजिस्ट्रार शैल नॉट बी एब्सेंट फ्रॉम द कोर्ट विदाउट लीव ऑफ द चीफ जस्टिस एनी अदर ऑफिसर ऑफ द कोर्ट विदाउट लीव ऑफ द रजिस्ट्रार। In the absence of the registrar, the additional registrar, ठीक है, may assign the registrar, and the registrar may, with the privileges, delegate. The registrar shall, subject to any directions, users allocate duty of registry among the other officers. The seal of the court shall not be affixed by any certified copy issued by the court, save another authority the writing number. In addition to any other power under Rule 9. ऑर्डर एडवोकेट्स एंड एडवोकेट्स ऑन रिकॉर्ड, ये भी डिफ्रेंसिएशन होती है। एडवोकेट्स कौन होते हैं सुप्रीम कोर्ट में, एडवोकेट्स ऑन रिकॉर्ड कौन होते हैं। देयर शैल बी केप्ट सेपरेटली अ रोल ऑफ सीनियर एडवोकेट्स एंड एडवोकेट्स ऑन रिकॉर्ड। सुप्रीम कोर्ट में ज़रा देखने वाली बात ये कि सीनियर एडवोकेट्स का थोड़ा सा कॉलम होता है या थोड़ी सी आप समझते हैं कि रिकग्निशन एक एक्स्ट्रा लेवल पे मिलती है सीनियर एडवोकेट्स को, जैसे रूटीन में होते हैं SACs जिनको कहते हैं। सीनियर एडवोकेट और एंड an advocate in court shall be entitled to appear and plead before the court on signing his respective role, provided that an advocate shall not be allowed to sign the role unless he produces a certificate of enrollment from the Pakistan Bar Council, and provided further chief justice and judges may refuse to allow a person to sign the role, remove his name from the role after the forwarding of oral hearing if he has at any been judged guilty of professional misconduct or is otherwise he has time being अच्छा misconduct or is otherwise considered unfit to enroll or allowed to remain as an advocate. Supreme Court रोक सकता है। Senior advocates shall have precedence over other advocates and the provision of the first schedule to the rule shall apply to senior and advocates. A person shall not be qualified for being enrolled as an advocate unless he has been not less than 7 years enrolled as an advocate of High Court, has been certified in a duly authenticated form by the Chief Justice and Judges of the High Court that he is a fit and proper person to appear and plead as an advocate before the Supreme Court। मतलब बेसिकली इसकी जो 7 साल की प्रैक्टिस होनी चाहिए आपकी हाई कोर्ट में और सर्टिफिकेशन आपकी होनी चाहिए, मतलब जो आपकी फिटनेस सर्टिफिकेट आपको मिलता है फ्रॉम द हाई कोर्ट, जिसमें अक्सर लोग अट जाते हैं, वो 7 साल में के बाद आपको हाई कोर्ट से लेना पड़ता है। उसके बाद सुप्रीम कोर्ट में अप्लाई करते हैं, फिर आपकी एक कॉन्स्टिट्यूशन उधर एक पूरी कॉन्स्टिट्यूट हुई होती है बेंच, वो आपको सर्टिफिकेट देती है या नहीं देती है, रिफ्यूज़ करती है। तो ये क्लैरिटी है थोड़ी सी। provided that the chief justice and judges may grant the enrollment of a person not qualified as enforcement as aforementioned if in their judgment he is qualified by knowledge, ability and existence to be called as an advocate. The chief justice and the chief justice and the judges may select from time to time from among those whose name on the roll of the advocates. Persons who are judged by their knowledge, ability, and experience to be worthy of being granted the status of senior advocate and signing the role of senior advocate shall assume the said status. A senior advocate shall pay an enrollment fee of Rs 5,000. No advocate other than the advocate on record shall appear and plead in any manner unless he is instructed by an advocate on record. The role of senior advocates, and advocates on record shall be kept by the registrar and shall contain salary. Role बनता है senior का, normal का और advocate on record का. Dress of senior advocates and advocate on record shall be short coat और शेरवानी of black material. ठीक है. शेरवानी होती black material की. Senior advocate shall wear the gowns throughout the year. Assigning fee of Rs. ठीक है. An advocate general provided shall have precedence immediately. An advocate general of a branch shall have precedence immediately after the attorney general. But the seniority of advocate general. The attorney general, deputy attorney general, an advocate general of an advocate general of an additional advocate general shall be by virtue of their offices and the status of the senior advocates in the Supreme Court, notwithstanding that their names are not born on the roll of senior advocates, subject to the proceeding rule of disorder. An advocate appearing before the court shall have proceedings among the senior or other advocates, as the case may be, according to the date of his enrollment as an advocate or other advocates in the court. An advocate of 5 years standing in the Supreme Court shall be qualified to be registered as an advocate on record on making an application on this behalf. No advocate. An advocate of 5 years standing in the Supreme Court before the court shall have precedence over the senior and no advocate of 5 years standing in the Supreme Court shall have be qualified to be registered as an advocate on court making an application. 5 years से ज़्यादा इसकी स्टैंडिंग हो जो सुप्रीम कोर्ट में वो एडवोकेट ऑन रिकॉर्ड नहीं आ सकता. मतलब 2 एडवोकेट्स आप असाइन कर सकते हैं, एडवोकेट एंड एडवोकेट ऑन रिकॉर्ड. वो 5 years से ज़्यादा एक्सपीरियंस हो जाए तो एडवोकेट ऑन रिकॉर्ड नहीं आ सकता. नो एडवोकेट देन एडवोकेट रिकॉर्ड शैल बी एंटाइटल्ड. एवरी एडवोकेट ऑन रिकॉर्ड शैल subscribe before the registrar a declaration in Form 2 or Form 3 of the form in the 6th schedule to the rules as may be appropriate of his case undertaking to observe the rules, regulations, order, practice of the court, and to pay all fees and charges due to payers. ठीक है. A senior advocate or an advocate on record who wishes to suspend his practice by reason of his appointment on any office of the profit under the government or is being engaged in another profession of any other reason shall give intimation therefore through a registrar. अच्छा, एडवोकेट ऑन रिकॉर्ड हो गया. देखते हैं इंस्पेक्शन सर्च ETC एडवोकेट बिजनेस इन चैम्बर्स वाला जो पेज है, पेज नंबर 14. एप्लीकेशन फॉर रिवाइवर ये हो गया जी. एप्लीकेशन फॉर रिवाइवर और सब्स्टिट्यूशन, एप्लीकेशन फॉर डिस्कवरी एंड इंस्पेक्शन, एप्लीकेशन फॉर डिलीवरी ऑफ interrogatories, certifying of cases as fit for employment of advocates, application for substitute services, registration of petitions, appeals, suits and other matters. अप्रूवल ऑफ इस तरह की चीज़ें चैम्बर में होती हैं. ठीक है, दैट्स नॉट सो समथिंग ऑफ माई कंसर्न. अच्छा, ये सुप्रीम कोर्ट रूल्स पढ़ने का फ़ायदा ये है कि हमें ये समझ आती है कि जो ये जनरल पब्लिक के लिए भी और लॉयर्स के लिए तो स्पेसिफिकली कि हमें पता होना चाहिए कि सुप्रीम कोर्ट की कॉम्पोजिशन किस तरीके से होती है, क्या मामला चलते हैं. जो मीडिया में आए दिन चीज़ें आती हैं कि बेंच को तोड़ दिए, बेंच कॉन्स्टिट्यूट कर दिए, किस तरह चलते हैं. अच्छा, इंस्पेक्शन सर्च 22 पे है, ये देखते हैं इसमें क्या कहना चाह रहा है 22 पे। इंस्पेक्शन सर्च है जी। Subject to provision, the rules are a party to any cause, matter, appeal who has spread shall be allowed to search, inspect, or get copies of all pleadings and document record in the case or payment. Um, the record in the case on payment and the prescribed fees and charges the court at the request of person not at party may or good cause show allow such inspection or grant such copies. ठीक है, ये inspection and documents की तो notices of motion hands. जजमेंट डिक्रीज एंड ऑर्डर कॉन्स्टिट्यूशनल बेंचेस में चले जाते हैं। कंपोजिशन ऑफ बेंचेस में देखते हैं बेंच किस तरह कंपोज होते हैं। 24 सेव एज ये ऑर्डर 6 है। सेव एज अदरवाइज प्रोवाइडेड बाय लॉ or by rules every cause, appeal or matter shall be heard and disposed of by a bench consisting of not less than 3 judges to be nominated by the Chief Justice, provided that all petitions for leave to appeal from appellate and revisional judgments and order made by a single judge is in the law high court. अच्छा, appeals from judgments, orders of service, tribunal or administrative court, and appeals involving grant of bail, cancellation of bail may be heard and disposed of by a bench of 2 judges but the Chief Justice may in a fit case orders of the service tribunals or administrative courts, and appeals involving grant of bail, cancellation of bail may be heard and disposed of by a bench of 2 judges, but the Chief Justice may in a fit refer any cause or appeal as aforesaid to a larger bench. ठीक है, मतलब बता रहे हैं कि जजमेंट जो सर्विस ट्राइब्यूनल की दो ने सुननी है, प्रोवाइड फर्दर इफ द जजेस हियरिंग पिटिशन और एन अपील आर इक्वली डिवाइडेड इन ओपिनियन द पिटिशन or appeal as the case may be shall in the direction of the Chief Justice be placed for hearing and disposed either before another bench or before large bench to be nominated by the Chief Justice. Appellate jurisdiction has civil appeals under Article 185 2DE of the Constitution. No notice of motion in relation to a civil appeal under this order shall be entertained unless it is accompanied by a certified issue by the High Court. अच्छा, ये appellate jurisdiction है क्या civil appeals का under 185 TE of the Constitution? No notice in motion in relation to civil appeal under this order shall be entertained unless it is accompanied by a certificate issued by a High Court concerned that the case involves a substantial question of law or the interpretation of the Constitution, or by a certificate as set out in Form 1346. The petition appeal shall be presented within 30 days from the date of the grant of the certificate by the High Court or the date of impugned judgment, decree, or final order of the High Court. The court may, for sufficient cause, extend the time. The petition appeal shall set forth the appellant's objection civil appeal. ये है क्या बेसिक नो, ये है जी नो नोटिस मोशन no notice of motion in relation to civil appeal under this order shall be entertained unless it is accompanied by a certificate issued by a high court concerned that the case involves a substantial question of law as to interpretation of the constitution, or by the certificate as to the petition shall be presented within 30 days from the date of grant of the certificate under the high court or the date of impugned judgment or decree, final order in the High Court, provided that the court may, for sufficient the petition of appeal shall set forth the appellant's objection or the decision of the High Court, and an appellant shall not an appellant shall not accept by leave of the court urged to be heard in support of any other. ground, but the court in deciding the appeal shall not be confined to the grounds of objection as set forth in the petition. Further, the court shall not rest in any decision on any other ground unless the party who may be affected by thereby has had a sufficient opportunity of contesting the appeal on the grounds. The petition of appeal shall be accompanied by certified copies of judgment and decree of final order appealed against the courts below, a certified copy of the certificates granted in Article 185(2)(f), where the certificate is not embodied with the judgment, an affidavit of service of copy of the petition of the appeal on the respondent. में if it file in the court. ठीक है, ये भी उसमें बता दिया है. For leave to appeal in civil proceedings में आपने leave to appeal पहले लेनी पड़ती है, जिसको कहते हैं CPL. And a petition for leave to appeal shall be lodged in this court within 60 days of the judgment, decree, or final order sought to be appealed from, or as the case may be, within 30 days from the date of the refusal of the grant of certificate under Article 185(2) of the by the High Court, provided that the court may, for sufficient cause, extend the time. A petition for leave to appeal shall state sufficiently and clearly all points of law which arise for determination, and all such facts as it may necessary to state in order to enable the courts to determine whether such leave ought to be granted, and shall be signed by the counsel or an advocate on record for the petitioner or by the party himself if he appears in person. The petition shall deal with the merits of the case only so far as is necessary for the purpose of explaining and supporting the particular grounds upon which the leave to appeal is sought. And where the petition is moved through an advocate on record, it shall cite all previous decisions of the court, which is the best knowledge of. The petitioner shall lodge at least 3 copies, unless required otherwise by the court, of his petition for leave to appeal. The judgment, decree, final order sought to be appealed from one copy of which shall be certified as correct, together with grounds of appeal or application before the High Court. The man shall lodge at least 3 copies, unless required otherwise by the court, of his petition for leave to appeal. The judgment, decree, final order sought to be appealed from one copy. सॉट टू बी अपील. अच्छा, एक हमने उसके साथ लीव टू अपील देनी है. एक जजमेंट, डिक्री, फाइनल ऑर्डर सॉट टू बी अपील्ड from one copy of which shall be certified as correct, together with grounds of appeal or application before the High Court. ये हो गया, मतलब प्लेंट होगी और साथ में आपकी जो जजमेंट डिक्री होगी. पेपर बुक ऑफ द हाई कोर्ट इफ एनी एंड द अदर रिकॉर्ड ड्यूली अटेस्टेड बाय द एडवोकेट ऑन रिकॉर्ड ऑफ द पिटिशनर. द ऑर्डर ऑफ द हाई कोर्ट रिफ्यूजिंग ग्रांट ऑफ certificate if any under Article 185. अच्छा, the order of the High Court refusing grant of certificate if any other. अगर कोई आपको हाई कोर्ट सर्टिफिकेट नहीं दे रहा, उसका अपने साथ लगाना है. An affidavit in support of allegations of fact prescribed by Rule 4 order. ये order पता नहीं कौन सा बनता है. 10, 15, 17 hereinafter contained, and unless a caveat as prescribed by order 17 Rule 2 has been lodged by the other party who has appealed in courts below, an affidavit of service of notice of the intended petition upon such party, the petitioner shall on demand furnish to other parties at their expense on the prescribed charges copies of all or any other documents filed by him or the courts. In an appropriate case, the registrar may require the petitioner to supply in advance of hearing the petition copies of the orders made in case by all high courts. In an appropriate case, the registrar may require the petitioner to supply in advance of the hearing of the petition copies of the order made in the case by all courts subordinate to the High Court, as well as grounds of the petition on of any earlier appeal in case these documents are not already included in the paper book record of appeal as mentioned Rule 3 of this order, save in case where caveat as prescribed by Rule 2 of Order 17 has been lodged by the other party who appeared in the court appealed from a petition for leave to appeal shall be heard ex parte, but the court may direct the petition to issue notice to other party as may deem fit and adjourn the hearing of the petition, which shall be posted for hearing of the after. ठीक है, ये भी हो गया. where appellant has lodged. अच्छा, हमने कॉम्पोजिशन भी देख ली कौन बनाता है, किस तरीके से बनती है। जो दो दो बेंचेस नॉर्मली सुनते हैं कैंसलेशन ऑफ बेल के केसेस हो गए या ट्राइब्यूनल के हो गए, या कुछ चीफ जस्टिस को इख्तियार होता है कि बेंच को जितना मर्जी बड़ा एक्सटेंड कर दे रेलिवेंसी ऑफ द फैक्ट्स देख के। तो हमने ये देख लिया कि कौन डॉक्यूमेंट्स आ लगता है। प्रिपरेशन ऑफ रिकॉर्ड किस तरह होता है। एज सून एज पिटिशन ऑफ अपील हैज़ बीन लॉन्च्ड इन द रजिस्ट्री under Article 7 of the court has made an order granting leave to appeal under orders 8. The appeal shall be registered and the appellant shall within 60 days file in registry the required number of copies of the record and additional documents if so ordered by the court. ठीक है, where an appeal has been admitted by an order of this court, the registrar shall notify the respondent by the order of this court granting leave to appeal and shall also transmit a certified copy of the order of the registrar of the High Court announced. The registrar shall then send for the अच्छा the registrar shall then send for the original record from the High Court, and the registrar of the High Court shall within the convenient speed arrange for transmission of such record to the registrar of the High Court. If printed paper books had such prepared for use in the High Court, at least 12 copies therefore shall also be transmitted along with the original record. While तभी जो है एक्सपेंसिव काम होता है सुप्रीम कोर्ट का, उसमें कॉपीज काफ़ी लगती हैं, तो आपका पेपर बुक के जो एक्सपेंसेस है वही अच्छे खासे आपके जो है दरमियान में आ जाते हैं। अच्छा, वे द एपेलेंट फेल्स टू हैव द रिकॉर्ड प्रिपेयर्ड विद ड्यू डिलिजेंस, द रजिस्ट्रार शेल कॉल अपॉन हिम टू एक्सप्लेन हिज डिफॉल्ट, एंड इफ नो एक्सप्लेनेशन इज ऑफर्ड और इफ द एक्सप्लेनेशन ऑफर्ड is, in the opinion of the registrar, unsatisfactory, the registrar may issue a summons to the appellant calling upon him to show cause before the court at a time to be specified in the said summons why the leave to appeal should not be rescinded. The respondent shall be entitled to be heard before the court in the matter in the said summons and ask for this cause. ठीक है, ये भी हो गया। Shall show due diligence in the matter as far as required for him, but the negligence part will not excuse delay in completion of the record. If the preparation, इसके तकरीबन 100 जो हैं हमने 30 पेजेस तो पढ़ लिए हैं। If the preparation of the record of the printed paper books prepared for the use of the High Court may be included if sufficient number of such paper book is available within 30 days from the date of grant of leave to appeal, the appellant shall pay court fee in respect of the appeal according to scale laid down number item number 2 of the part 1. Every appellant and each one who has entered an appearance shall be entitled to receive his use a number of copies of paper book not exceeding 3. The parties shall be severely responsible for placing on the paper book to be used at all hearing all documents that may be necessary for the due appreciation of the case. In case of objection by any party to inclusion, non-inclusion, or any other document which is desired by any other party, such document shall be included, but at the cost of the party desiring such inclusion, provided that if the court, when deciding the appeal, considered that any document so included was either inadmissible in evidence or wholly irrelevant or unnecessary for the purpose of the appeal, and the cost incurred in respect of such document shall be borne exclusively by the party whose instance such document was included. ठीक है, ये भी हो गया। Change of part. Where the appellant desires to withdraw his appeal, he shall make an application to the effect of the court. The cost of the appeal with the security entered into by the appellant, if any, shall then be dealt with in such manner as the court may deem fit. If an appellant fails to take any steps in the appeal within the time fixed for the same by the rules, or if no time is specified, it appears to registrar that the appellant is not prosecuting his appeal with due diligence, the registrar shall call upon him to show cause why the appeal should not be fixed before the court for admission on account of non-prosecution. The registrar shall send a copy of summons mentioned in the my last proceedings rules to every respondent who has entered an appearance, and every such respondent shall be entitled to be heard before the court and ask for his cost and other relief. The court may, after hearing parties, dismiss the appeal for non-prosecution and give other such direction therefore justice may require. Appearance by respondent. As respondent shall enter an appearance within 30 days of the receipt of notice from the registrar regarding grant to leave to appeal ग्रांट ऑफ लीव टू अपील, जो लीव टू अपील देगा उसके 30 दिनों के अंदर रिस्पोंडेंट ने उसमें आके पेश होना सुप्रीम कोर्ट में। ये भी हो गया। अच्छा, lodging of concise statements. Appellants and the respondent may lodge in the registry the required number of copies of of the concise statements, of the concise statements, of the facts of the case and of the arguments upon which they propose to rely at any time before the appeal is set down for hearing. Two or more respondents may, at their own risk as to cost, file separate concise statements in the same appeal. Every party shall, after filing the concise statements forthwith, give notice therefore to the other party. They shall thereafter be entitled to receive two copies of the concise statements filed by the opposite party in the applying therefore. ये हम थोड़ा सा देख लेते हैं इसमें और क्या चीज़ है जो हमारी इंटरेस्ट की। कॉन्स्टिट्यूशन बेंच ने पढ़ ली, सिविल अपील्स की हमने देख ली क्या नोयत होती है, किस तरीके से नोटिस इशू होते हैं, पार्टी पिटिशन फॉर लीव टू अपील इन सिविल प्रोसीडिंग्स किस तरीके से ड्राफ्ट होती हैं, प्रिपरेशन ऑफ रिकॉर्ड, अपीयरेंस बाय द रिस्पोंडेंट, पिटिशन जनरली, लॉजिंग ऑफ कंसाइज स्टेटमेंट, ये भी हो गया, हियरिंग ऑफ अपील, मिसलेनियस। अच्छा जी, इसको देखते हैं। एप्लीकेशन फॉर एनफोर्समेंट फंडामेंटल राइट इन आर्टिकल 184(3), ये अच्छा है क्योंकि इसकी बेसिस पे काफ़ी चीफ जस्टिस जो है फेमस जो है वो हमारे फेमस भी होते हैं और हमारे आप समझ लें कि बदनामी के बास भी बनते हैं, इफ़ आई मे से सो। 45 पेज नंबर है, हाँ ये आ जाती है जी, इसको थोड़ा सा देख लेते हैं। एप्लीकेशन फॉर एनफोर्समेंट ऑफ फंडामेंटल राइट्स एंड आर्टिकल, ये हेबियस कॉर्पस भी इसमें बीच में आती है ना। एप्लीकेशन फॉर रिट ऑफ हेबियस कॉर्पस शेल बी फाइल्ड, मैंने आपको बताया था रिट में हेबियस कॉर्पस क्या होती है, शेल बी फाइल्ड इन द रजिस्ट्री एंड शेल बी अकम्पनीड बाय एन एफिडेविट बाय अ पर्सन restrained stating that the application is made at his instance and setting out the nature and circumstances of the incident. The application shall also state whether the applicant has moved the high court concerned the same relief and is so obviously क्योंकि हाई कोर्ट में मेन जुरिडिक्शन बनता है तो हमें पहले बताना है कि हाई कोर्ट में आप चलेंगे, further with the person restrained is unable owing to the restraint to make the affidavit, the applicant shall be accompanied by an affidavit to the like effect made by some other person which shall state reason why the person restrained is unable to make affidavit, that the application shall be heard by a bench consisting of not less than two judges. The court of the penal prima case for granting application is made out. A rule of nisi shall be issued calling upon the person against whom the order is sought to appear on a day to be named herein to show cause why such order shall not be made, and at the same time to produce in court the body of the person or person on the return day of the rule, the day which hearing of the return, the court shall obtain the body. अच्छा ठीक, हेबियस कॉर्पस की ये बेसिकली हेबियस कॉर्पस की बातें की गई हैं। एप्लीकेशन फॉर द रिस्पॉन्स फॉर एनी अदर फंडामेंटल राइट शैल बी फाइल इन रजिस्ट्री, इट शैल सेट आउट द नेम एंड डिस्क्रिप्शन ऑफ द applicant, the relief sought, the grounds of which it is sought shall be accompanied by an affidavit verifying the facts and relied upon. At least 8 copies of the said application shall be lodged in the registry. It shall also state whether the applicant has moved to high court concerning the same relief, and if so, if with that result the application shall made by notice of the motion, but the registrar may in appropriate cases put up the application before the court for order as to issue of notices. अच्छा, ये एप्लीकेशन की बातें उन्होंने की हैं। अच्छा, रिव्यू की जो है इसमें, अब रिव्यू में होता क्या है, रिव्यू तो आप पढ़ लेते हैं क्योंकि रिव्यू भी मुझे काफ़ी इंटरेस्ट करता है। अच्छा, सब्जेक्ट टू द, अच्छा ये ऑर्डर 21 है, ऑर्डर 26 है इनफैक्ट, नॉट 21, ये है जी सब्जेक्ट टू द लॉ, subject to the law, and subject to the law and practice of the court may review the judgment or order in a civil proceedings on grounds similar to those mentioned order uh, rule 1 of the code in criminal proceedings on the grounds of an error apparent on the face of the record. Application for review shall be filed by the registry within 30 days after pronouncement of the judgment, as the case may be making of the order which is sought to be reviewed. The applicant shall, after filing the application for review, forthwith give notice therefore to the applicant to the other party and endorse a copy of such notice to the registry. Every application for review shall be accompanied by a certified copy of the judgment order or order accompanied by of and where the application proceeds on the grounds of a discovery of fresh evidence, certified copy of the document if any other if any, relied upon, shall be annexed to the applicant, together with the affidavit setting forth the circumstances under such discovery has been made. The advocate signing the application shall specify in brief the points out with the appeal for the probation shall add. And in case concluding the review application filed was vexation or frivolous, the advocate in the drawing application shall render himself liable to disciplinary action. अच्छा, अगर रिव्यू आप में आप डिसिप्लिनरी आपके खिलाफ एक्शन भी ले सकते हैं अगर आपको लगे, अदालत समझे कि आपने उसको फ्रिवलेसली फाइल किया है. आई थिंक प्रोसीडिंग्स रिलेशन टू कंटेम्प्ट ऑफ कोर्ट की तो हमें पता ही है, काफ़ी वाइडली सेक्शन 3-4 भी हमने पढ़ा हुआ है. तो उसके अलावा देख लेते हैं कि बहुत ज़्यादा इंटरेस्टिंग चीज़ है तो पढ़ लेते हैं. वरना आई थिंक दैट्स इट. एक जो है पिटिशन ड्राफ्ट करनी है, फिर उसके लिए जाना पड़ेगा मुझे. Proceeding in relation to contempt of court है, costs, taxation, notice of proceeding to law officer of the state, forms to be used, service of documents होता है, commissions होते हैं, inherent power होती हैं, rules as to printing record, fees to advocates. ठीक है, ये सारी जो प्रोसीजर नोटिस ऑफ प्रोसीडिंग लॉ ऑफिसर, सर्विस ऑफ डॉक्यूमेंट्स देखते, सर्विस ऑफ डॉक्यूमेंट, फॉर्म्स टू बी यूज्ड में देखते हैं 58 में कौन से फॉर्म यूज हो रहे हैं. Forms to be used. Every writ, summon, order, warrant, or other mandatory process shall be signed by the registrar with the date and year of the signing and shall be sealed with the seal of this court. The form set out in 6 schedule to these rules or forms substantially to the like effect writ with such variation as the circumstances of each case may require shall be used in all cases where those forms are appropriate. अच्छे फॉर्म्स की टेक्निकलिटीज़ हैं जो कोर्ट स्टाफ के लिए प्रॉब्ली बनाई गई हैं. ये सुप्रीम कोर्ट रूल्स हैं जो थोड़ा सा अगर हम इसको देखते हैं तो ये आपके सुप्रीम कोर्ट की प्रैक्टिस के लिए आप समझ लें, जो उसका जो है ना पूरा कट्ठा चट्टा जो है आपके सामने रख देती है कि सुप्रीम कोर्ट में प्रैक्टिस होती किस तरीके से है, वहाँ के रूल्स क्या हैं, क्योंकि रूल्स और ज़ाब्तों के हिसाब से सुप्रीम कोर्ट के हाई कोर्ट चलते हैं. हाई कोर्ट रूल्स एंड ऑर्डर्स उस तरह सुप्रीम कोर्ट रूल्स एंड ऑर्डर 1980 के काफ़ी रेलिवेंट होते हैं. तो होपफुली हमने इसे सीखा होगा. थैंक यू जी.